Thanks also to Paul for offering up his time slot, and I will do my best to not fall too much behind the level of theoretical sophistication, which of course you are part of, and it will fall back behind a certain level of sophistication in one respect. Of course, the greatness of the show is that it shows that the public and the private and the governmental and the power and the private and the body are all intertwined and connected and interlaced and mutually dependent, while people with at least the legal background are used to dissect things and keep them apart, and keep them separate. So and these separations have their limits, but they're functional in a certain respect, just because it still makes a very simple difference whether something is legal or not. So as much as you can, relate all these categories and merge them into one another on another level of daily life, it makes a difference whether you're allowed to do a certain thing or not, at latest when you're confronted with the police. So, when I sent the abstract for today's presentation, Iris Dressler, who I thank for the possibility of being here with her colleagues, of course, noticed that it would be a good idea to not only talk about the agreements between artists and institutions, that's what I focused on a little bit in the article, but also to shed some light on the legal questions involved and how the issue at hand relates to questions of artistic freedom, and in particular to the fact that artistic freedom is constitutionally guaranteed in most of the countries that many of us usually work in, with all its unclarities about where these countries are situated. Before I do that, it's very crucial to talk about one's own position. I have graduated from law nearly 30 years ago, and I have never exclusively practiced it. But what I did extensively was to negotiate the conditions of participation for artists in exhibitions, festivals, museums, world's fairs, manifestas, places like PS1, the festival regions, you name it, as curator, production manager, production coordinator, managing director. I did that many times on the side of the presenting institutions, but I also regularly consulted artists who were engaged in conflicts or who wanted to organize their relationship to presenters in a more satisfactory way. So there are two important caveats to the little bit of legalizing that you will witness in the coming 20 to 25 minutes. First, I have to simplify and assume that the things that we talk about happened in Germany or Austria, because I do not know anything about Spanish law. Second, I have to point out again that I'm not a professional, meaning liable, lawyer, but an experienced curator and production manager in the field of contemporary art with some studied legal background. Let's start legalizing with an important distinction. And it's funny how this distinction already seems to translate some of the philosophical and political notions that we heard of yesterday into very, pragmatic legal terms. Law is not one homogeneous system. The one distinction that we need most for the case in question is the distinction between public law and private law. In very short, public law regulates the relationship between the state and its citizens. Private law deals with the relationship between private individuals. It reminded me of the talk yesterday between soft and hard censorship, and maybe it's quite easy to clarify this distinction. Private law is where two people have a conflict, and the conflict stops, at least for the state, the second they are in agreement. So you can have a lawsuit which goes on for years. At any time, private individuals can say, okay, let's settle it. You cannot do that with the state. If you murder somebody, take matters worse, you cannot negotiate that you will somehow not be fined for it. Okay. The best known element of private laws are contracts. We all know contracts, and we're engaging in contracts all the time. My coming here and speaking for a certain fee is regulated by law just in so much as my email exchange with Iris Dressler constitutes a contract between myself and the Baden-Württembergischer Kunstverein. The one overarching principle of private law is pacta sunt servanda, meaning contracts are to be honored. Public law has nothing to do with my relationship with Baden-Württembergischer Kunstverein at that moment. And it has therefore nothing to do with the state guaranteeing my freedom of expression. If I were to behave badly now, Iris Dressler could turn off my microphone, ask me to leave, or ask a security guard to accompany me to the door, based on nothing more than her private rights as the host. Most conflicts between presenting institutions, curators, artists, or artists and curators, do not even touch the sphere of public law, and therefore do not relate to the constitutional guarantees of artistic freedom. So why is this? Constitutional guarantees in most cases protect the individual from unwanted interference by the state. The constitutional guarantee of artistic freedom, however, does not guarantee a trouble-free production process, but it guarantees that the state will not interfere with it. If the state had passed a law limiting to the right to show at Kunstverein to members of artistic unions, this would be a violation of the constitutional guarantee. The same goes for the case that a state would declare that certain subjects or motives would be banned from depiction. So if the state would say, you're not allowed to paint, to take the federal president as a motive, period. That would be an act of unlawful, unconstitutional act by the state to pass that law. But if a museum has a conflict with an artist, this is usually beyond the reach of public law. And it does not necessarily matter legally if the museum is state-funded or not. Most of the modern neoliberal public-private partnership reformed institutions, most of the modern museums are organized as independent legal entities and are as such considered legally private in the sense of them being what the Germans call juristische Personen, meaning legal person. In that sense, an individual with all the rights to engage in contracts, just as any other physically private individual. So to sum this chapter up, let's look at a few standard situations and let's see whether they're regulated by public law or private law. So we do that very short and you can read the list yourself. So I would say the standard business between artists and institutions usually is a contractual relationship, and conflicts like these would be conflicts on the principle of a contract. So the parties could sue each other, they could ask for damage, they could, if Iris Dressler throws me out, I could still ask for the fee, and then I could take the Kunstverein to court to battle for it, but it would not be a matter of any state doing anything else than providing a court. So, of course, the state will have a say in it, because at least I might have to take the Kunstverein to a court, and the court is, of course, an organ of the state. So there is a relationship, but as I said before, all of these conflicts will stop in a second we agree. So the court will say, goodbye. Even after 15 years of a lawsuit, the court will say, fine, you settled, leave. It's your private business. So this is an important distinction. Public law, on the other hand, and you see those cases here, is actually, at least in the Western context that I worked more in professionally, is more of the exception. So you see the examples that I show here, usually we associate them with non-democratic societies in a more very broad sense. And of course, from both systems, art can come into trouble. And now we'll start to link it a little bit to the case in question. meaning also to Ministerial sculpture, but not only, as we will see. From private and from public law, from both sides, one could talk about this sculpture. The public law side could say, well, maybe there's a penal law problem in it. Offense of the monarch. Even in Germany, I looked it up yesterday, surprisingly, there's the article which says offense of the federal president. So that can be punished by law. That's only been done 2 times, obviously, in about the last 20 years, but it's an offense. And there's another article that says offense of a foreign head of state. So, you know, even here, somebody could theoretically think, well, this could be a penal law problem. In most cases not, because for the foreign head of state, it seems as if the other state has to ask Germany to penalize it. So we'll see if this happens. But, and that's, I would say, much more often the case, private law comes into contact with constitutional guarantees the moment it's conflicted. And one of the leading cases for this balance between private rights and constitutional guarantees is, and you can even look it up in English because it's well translated on the Federal Constitutional Court's website, is the so-called Ezra case. And in very short, the Ezra case dealt with a novel that a writer wrote based on a love affair that he had. And then the former lover and the mother of the former lover sued the author and the publishing house and succeeded in having the novel banned from circulation on the grounds of their personality rights being violated by the depiction of sexual detail, by stories about a dead, very sick child, intimate details that the former lover and her mother considered offensive. And in that ruling, the federal court spelled out, for example, the principles that you can read here, which in short is always the same. If private right conflict with artistic freedom, judges need to balance out those questions. So there is no absolute dominance of the constitutional freedom of art vis-à-vis private rights. Judges are asked to balance it. They need to make an argument, a structured argument, why in a particular case the artistic freedom enjoys more protection or the private. So in the Ezra case, for example, the court said the mother of the former lover, who was a more public figure, was not entitled to have the novel banned, but the former lover was entitled because of the sexual detail, the intimacy, the protection of the private rights. We will not judge the case and talk about the sculpture too much, but it struck me when I thought about it the last days. First 2 things struck me, and I have to say that. I found the sculpture very discreet, very gentle, very quiet, especially after having heard about it all the time and not having seen it until yesterday. But having said that, one thing strikes me from a legal perspective, and don't get me wrong, I'm not suggesting anything. It's now month and month and month that we only heard about the monarch, the king, and the rights of the king, and not offending the king, and what else, and who defends the king. Now, surprisingly enough, from all I can say, the best chances to have this sculpture incriminated is not the king, is not the state, it's the children of the Mitlia Chungaras. They are the ones who have the best claim. And I'm not saying that they will win it. I'm not saying that. And I'm not suggesting that they should do it. But I have to tell you, from what I know, that this is an argument which has not ever been raised in that discussion. And that is where you see where private rights meet constitutional guarantees of artistic freedoms. The children of the Mitlia Chungara could try. We don't know what will happen, but they could try, and they have a legal argument that supports it. But they could lose. The Republic of Germany could say that artistic freedom is a more important value. But I wanted to raise it because it adds an element also to the discussion which has not been raised so far to my knowledge. So again, we have to keep in mind that the guarantees for artistic freedom do not usually help when it comes to attempts by institutions or their representatives to interfere with the selection of works for an exhibitions. Museum directors and curators have all the right to select. In fact, selecting and not showing is the nature of curating. Not showing somebody's art is possibly a breach of a loan contract. As we have heard yesterday, there was a loan contract, so definitely the museum would have been in breach if they had not shown the work. But it's only a constitutional problem if the state had directly interfered with that decision. It is widely accepted in the legal field that constitutional rights have no, and that's very technical, no direct third-party effect between private law subjects. You cannot sue the Kunstverein on constitutional grounds if one artist gets more production budget than the other. One could say all men are equal. Why are not all the production budgets equal? Well, because the Kunstverein has the right to deal with you on an individual basis. Employers are free to pay different salaries, or to give you another very simple example. If I were to commission an artist for a wall painting in my living room, and we would draw up a contract stipulating that I need to receive a detailed sketch beforehand, that's of course a perfectly legal contract, even though it applies, of course, what in state terms would be called pre-censorship. I would insist on knowing before what comes on my wall, that if the state would do that, that's censorship. If I do it, it's a valid legal contract in most cases. We could go into two different directions, and we should leave it up for discussions which one you would prefer to go. But I want to roughly sketch out with which options we're left based on the legal distinctions that I talked about in the beginning. One direction, and always a fruitful one, is to concentrate on the contractual possibilities which are open to artists and other participants in the process of contemporary exhibition making. Many of you know Seth Siegellaub's seminal work, The Artist Reserved Rights Transfer and Sale Agreement, by the way, which he wrote with the help of the lawyer Bob Boyansky. This is just one of the many examples of how artists try to achieve better control about their work and its presentation. But given today's subject, it struck me that most of these contracts want to protect the artists from being shown in the wrong places, in the wrong context, or in the wrong manner. But usually they rarely deal with ways to make sure that the work indeed will be shown. So, Siegellaub's contract, for example, specifically stipulates that the artist has to be notified about any exhibition of an already sold work by the buyer, but it does not oblige anybody to show a work. Another famous incident regarding artist rights has been the removal of a work by Takis from an exhibition at the Museum of Modern Art in 1968, which turned out to become a decisive moment in the formation of the Art Workers Coalition. And I always recommend going back to the Art Workers Coalition, but because until today, it's one of the best examples of combining general political demands with very specific demands of artists in their professional trade. So it does not fall prey to the trap of artists just asking for their rights without, thinking about a broader political agenda. But Takis removed his work already in MoMA's collection himself because he felt that it did not adequately represent his work. Subsequently, the Art Workers Coalition demanded that the museum should recognize an artist's right to refuse showing a work. And here you see it on the screen in a later, more general version. So you see it's all about control. If we look at these examples, we see that artists in the past have been more concerned with the possibility of work being chosen against their will than with the possibility that a work of them is not shown. So would the story have been different at MACBA if Ines Dujak had a contract which, for example, had stipulated a contractual fine of, let's say, $20,000 for the case that the work agreed upon in the loan contract will not be shown. This would be a contractual possibility to say, look, you want the work, great. If you decide not to show it, you pay a fine of $20,000. By the way, one could also argue that probably Ines Dujak might have suffered damages to her professional reputation by the act of MACBA. Maybe Ines Dujak could try to sue MACBA based on damages that she again feels she had suffered from that attempt to breach a contract. My guess, if she had asked for this contractual fine, my guess is that in this case, the controversy about the work would have happened prior to signing the contract, because nobody would have dared to sign such an outrageous demand. So they would have handed this contract from one hand to the other in the museum, and nobody would have known what to do with it. Oh, here's an artist who asked for a fine if we don't, what's going on? Difficult. As I said, I'm prepared to follow up with the individual artist's possibilities to negotiate his or her terms of engagement in the discussion. It is always a worthwhile agenda to develop new models for this relationship. But instead of being so purely practical, I would like, for the final minutes, I would like to use today's opportunity and the remaining time to complicate matters even further. I do not want to comment on things which happened inside MACBA and among MACBA staff, because I actually do not know what happened. But I can again go back to MoMA in 1969 and report a story which happened there because it is well documented. The image that you see, and it's again an image dealing with war, colonialism, atrocities. The image that you see is one of the most famous anti-war posters published in the United States after the My Lai massacre in 1969. The image that you see, it refers to an interview by a participant in the massacre admitting that babies had been among the 504 villagers killed by regular US troops. It's a very well-known poster, but it's a not so well-known story that MoMA, respectively members of MoMA's senior staff, had originally agreed upon to co-publish the poster together with the Art Workers Coalition. It was only hours before the poster was supposed to go to the press that the curator in charge, Arthur Drexler, then director of the Department of Architecture and Design, went up to the board and showed the final mock-up of the poster to the president of Board of Trustees, who was the then president of CBS. It is reported that the Rockefellers, also members of the board, have also been involved in the decision. Both Paley, the president of CBS, and the Rockefellers were supporters of the US intervention. To cut the long story short, MoMA decided not to be affiliated with the poster, and eventually issued a press release which stated the following: the museum's board and staff are comprised of individuals with diverse points of view. We've come together because of their interest in art, and if they are to continue effectively in this role, they must confine themselves to questions related to the immediate subject. But in the context of today's discussion, we're even more interested by the following paragraph, which directly points out institutional government. Mr. Paley, again the president, said he could not commit the museum to any position on any matter not directed to a specific function of the museum. And that the use, and now it's important to listen, that the use of the museum's name on the poster was a policy matter to be decided by the full Board of Trustees. So they did not even officially decide against it. They said, policy is a top-level decision. Policy needs the full board. And of course, the poster was published beforehand without MoMA. And when the issue was brought to the attention of the full board, the poster was already published without mentioning MoMA. So to come to an end, a report about the incident then in the New York Times mentioned the issue and said something interesting. The real issue is staff versus trustees, analogous to the troubles at certain universities. You remember the students' revolts in the US at that time, at the same time. It reminds of the troubles that certain administrators had, mandated by their boards to deal with the dissident students and had the rug yanked from under them, so the plug was pulled when it was felt that they exceeded their authority. To take this analogy to Makba's case would mean that Murray had to go not because of attempted censorship, but because he was not able to deal with the issue of the dissident students in a satisfactory way to the board. We cannot pretend as if our relationships in the arts were determined by law or private agreements without talking about power and politics. And that's where it starts to get messy. The messy part happens not in the area of agreements. The messy part in these cases can usually be found in the backstage of the very governance of the institutions itself. The messy business happens where board members talk informally to directors, where directors talk informally to sponsors, when husbands talk to their board member wives, or when wives talk to their politician husbands. The messy business happens when government officials drink coffee with participants, or, and we also need to talk about it, when curators do or do not talk with their superiors, and superiors do or do not remember what they're being told. To make matters worse, people are people, and people do change their minds. As much as these are theoretically legal issues, in reality, they're power games. Museum and artists are fully integrated into the parallelogram of economic and political forces of cities and states. At best, these powers are balanced out by a package of everything we talked about. Good laws, clever institutional architecture, statutes, regulations, contracts, etc., etc. It is tempting to quote Brecht's famous last lines of Der gute Mensch von Souverän, where the curtain is closed and all the questions remain open when trying to judge from the outside about the dynamics of the various levels involved at Makba. But what we do know is that the battle was eventually won and lost. And again, I agree with Ines Duyek that said we should remember that it was a won battle. Maybe not yet individually by the curators, and we hope they will win it in court. But it was a won battle for the exhibition and the artwork. The battle was eventually won and lost, not on the precise high grounds of law, but in the muddy waters of personality, power, and politics. Thank you.
Questions?
Rachel once explained to me that you would be allowed to destroy an artwork which you own, but you are not allowed to misplace it or to present it in the wrong way. Some years ago, two architects in Stuttgart lost the process against the city of Kassel because they demolished a big staircase on the place of the Continental. So maybe the laws have changed now. The art is now still allowed to destroy an artwork, but not to present it in the wrong way.
Well, that's a very popular question, and it's always an unsatisfactory answer. Yes, it is allowed to destroy an artwork. But there are some differences in certain countries. So in Switzerland, obviously, you need to offer it back to the owner, so there might be individual systems. But in Germany and Austria, I have already researched this. Yes, you can destroy an artwork. You cannot alter it. So the famous case is the fresco with naked bodies that the owner wanted to paint trousers on the naked bodies. So she was not allowed to do that in her own house, so to speak. So she was not allowed to change it for a fresco in a private house, but she was allowed to take it off completely.
Yeah, also, well, one comment, it would have been in the context of this poster very interesting to refer to the exhibition Road of Victory, when then the board said the museum is a weapon in the propaganda of war. This was in 1942, also the Museum of Modern Art. But there was here the post-capital exhibition, and inside there were a lot of copyright issues. And there was the law, he's also reporting to the government when they changed the public law around this copyright issue, intellectual property. And what he said when I went with him through the exhibition was for me very interesting, and maybe there's another thing is coming. When he said, when I enter through this door, I start to have to look at the things in the gray zone.
Yeah, I mean, it struck me, I forgot to say that before anyway, and I wanted to say it anyways. When I mentioned the children of Dimitri and Tungara, it's like if you open the Pandora's box, you never close it again. Because when I now walk through the exhibition, I realized that personality rights are all over the place. You know, the students from the Moroccan school, have they ever known that they will be in Württembergischer Kunstverein in the year 2015? Archival footage. Ethnographic imagery. I mean, is it that easy to say, well, just because this is a Kunstverein, these images are not colonial any longer? So, has any of those people ever thought of being exhibited in a Kunstverein? Our little email exchange, of course, says nothing about the use of the tape or the video. I don't know where it will be screened or not. In that case, I do not mind. That's why I prepared thoroughly to not say anything stupid. But you see, you know, it is all over the place. And of course, it's a gray zone. One important argument of the federal court in the Esra case was at least you have to derive your argument from the artwork as an artwork. So you have to read the novel based on the principle of the novel somehow. So you have to see, and that's maybe an argument of definitely pro Ines Dueck's sculpture, you have to see whether the sculpture itself pretends as if it were a true story, for example. So does the sculpture itself say, I want to offend, or does this? So you see, it's a tricky argument. So the gray zone is a little bit within those notions of the artistic intent versus the factual basis of, for example, a newspaper. A newspaper is simple, it's whether true or not, you know. There's no newspaper interpretation in a way. Daniel?
Yeah, it's yes, two points. One point is it's about the negotiation itself, that sometimes we put all the responsibility in the side of the institution, but this is also the responsibility in the artist side most of the time. We are fighting. I was involved in this artist union for many years, and we try to provoke even that the government legally adopting these good practices, that the people is obliged to have a contract with the museum. These are many rights that they are to protecting the artist, but also to protect the institution on both sides. So, and most of the artists, they don't like to do it. Sometimes it's because the property of the production, because if the museum, a public museum, this was under discussion in Spain, so discussing with the government and with the local government who will be the owner of the pieces that the museum, the public money are producing, because most of the artists, they like to produce in the museum, public museum, and then going directly to the gallery. This is one thing. And the other is about the context itself. My experience is like normally, for me, that happened in Barcelona. This is personally, this is something that I never felt before, even that it's in Barcelona, something like that. So it's quite complex because it's the context is quite specific now. But normally, every time that I need to go to the court for my practice, it was for something related always that it's about money, copyright issue, something like that. But then sometimes I was in some point establishing something that the government, even the security of the state say, this is terrorist information, it's not allowed to put it, but then we start to negotiate that this is the difference between language, the freedom, the gray zone, that you are going to most of the state and most of the museum, they don't like to fight for this. So normally you can negotiate that until you are flexible. But at the same point, a guy published a t-shirt with the same piece that I put in the museum, and he went to prison for 2 years.
Well, you know, first...
So this, the difference of the context is very important.
First issue of contracts, I have a somewhat split opinion. First, I think, yes, of course, every attempt to you know, try to get as much out of, as much clarity as possible helps, and most of the conflicts that I was involved in were, when people ask me, you usually ask, well, what has been agreed upon? And then the people says, oh, we did not talk about it. So a lot of times, you know, even talking about it helps. On the other hand, usually people know quite well what they can achieve or not in a given situation. So the sense for the power balance in the art world, unfortunately, is quite precise. So you usually know whether I'm the more known curator than the artist, whether I'm the unknown curator and the known artist, the big museum and the small. So it's like, usually, unfortunately, people have a quite delicate knowledge about where they are and what is in it right now. But so my plea is that artists who have the clout, they should use it. You know, so it's more for me, it's an obligation of better known artists to, you know, constantly work on that level, so that it, step by step becomes something that these institutions are used to. And the third, the panel law, the question of the t-shirt, I mean, that's exactly the privilege of art. There is the possibility that certain things are punished if they're not art, and not punished because they're art. That is the nature of the constitutional guarantee. So this is definitely worth something.
Now, we are losing this right, because this poster is 69. In the 80s, publicity can publish this with a problem. It was the sample that we discussed in the 80s with Benetton, with Oliviero Toscani, that the publicity sometimes, we are losing this freedom, this gray zone. We are losing this resistant space a lot of. I think we must take care about it, because you make this like a publicity to sell crosses or whatever. Maybe nothing happened. You put in the museum, that happened in the Renaissance Theater with these Catholic maxis or whatever. Then something is changing, and we need to take care of this.
By the way, for a Spanish context, there's an interesting side story to this poster that then 5 years later it was brought in the Guernica room. Yeah. And with the poster, Tony Shafrazi, when he sprayed on the Guernica, he was part of the Art Workers Coalition. So this conflict, there is a link to Picasso and Guernica at the same time, which is very interesting to follow in the book, especially in your context. But I'm provoking now. We could say we lose that freedom. On the other hand, we could also say we lose the snobism of saying, oh, we do not need to deal with those others, you know. So we can also say we become fully aware that, you know, right here, I mean, we're in the middle of a government district. You can walk to the government right through the corridor, you know. It's over there. They're sitting over there. It's not, you know, why should we be free, you know?
Yeah, but the interesting point why I fix it physical on the door is also this building is owned by the government, and it's owned, and with this level, every time in a very maybe naive way, I would say, if you are on this governmental ground, we have here a force for the rights, which we call public rights. So there is also then an agreement between the Kunstverein and the government to rent the building. And this is organized still through a public organization and based on a public contract. So by this connection, we are now since 1913 in this building. By this connection, we are standing with 2 feet on the ground, which I would call is the book of the German Constitution.
Well, this at least would be my summary anyway, that you have to ask for all possible freedoms and for your range of maneuvering, but more and more we have to get used to ask for it not on the grounds of some art, of some privilege for art, you know. So if we want to enjoy political range to maneuver here, then we want it as citizens, and we fight for it as citizens, and we fight for it for everybody. So this is, I think, it's getting more and more complicated to base those arguments on a privilege of art, even though there are arguments. But I think step by step, the other arguments are getting stronger. Arguments where just people join in the discussion and the fight and the battle and say, well, this is a battle for many people whose rights are being inflicted upon.
I was just, sorry, is this working?
Yes.
As far as I know, I mean, I'm not familiar with the market, but I'm guessing that it functions pretty much as all other European institutions. So I would say that I'm guessing the director has, together with the team of curators, discretionary power over what gets shown, meaning the board has no say at the creative level. Okay, of course, I mean legally, like as a term of like how the statutes of the institution function.
It doesn't,
So,
you know, I'm sorry, but...
No, it's not true.
Well,
but I mean,
yeah, okay.
This should be the model. So in this case, if we want to see it from a juridical perspective, Bartomeu Mari would have the right to say, no, I don't want to include this work in the show prior to signing the loan agreement. The moment when he signs the loan agreement, I think that it becomes a bit less clear whether he has the right or not to then step back from the agreement he already signed. But that's not really the issue here. I think the real legal issue here is the firing of the curators. You know, that falls back on this signing the loan agreement and then retracting from signing the loan agreement and not wanting to show the work.
Yes, but it's...
Because that would be like a case for
Yeah,
labor law.
it's the issue, but I'm afraid it's maybe not that complicated, because both issues will be solved on the basis of existing laws and contracts. So Spanish labor law will say something about it. So, you know, in the Austrian context, to fire without notice is very restrictively handled. So in an Austrian case, the chances to win that case, I think, are there. But winning would not mean you get your job back. Winning would mean you get 3 months paid between regular termination and termination without notice. So it's, you know, winning comes at a price in this case. But I think the other issue is, yes, even after the loan contract, you know, an institution can just breach a contract, but they will have to, you know, the artist would have right to claim damages. So this is the difference. This is the difference that I wanted to point out between public law and private law, you know. Private law is just between two people, and then they say, well, I have a problem, you broke my contract, I have damages, I don't know, I lose sales. Ines Guyak would have had to say, either I lose reputation and that cost me money, I lose potential sales and that costs me money. And so you will not be able to argue that on a constitutional ground, even though there are links between labor law and the constitution and freedom of speech, that you will be well consulted by your lawyers, you know.
The moment when, because, okay, like, when, of course an institution can breach a contract, but the moment when this contract is breached because of an issue of like freedom of expression, then it becomes a matter of public law. I know
it's a little, yes. I mean,
narrative,
we touch complicated ground. That's, you're right. If a court would have to talk about it, they would have to see whether the right of the institution to, I don't know, be the host in its own spaces is worth more. If the private autonomy of the private person museum validates
that. You don't have that right. As a private person, you don't have that right. For instance, you don't have the right to restrict access to the space.
No, I have that right. No, of course you have that right. I mean, that's, you know, this is what I wanted to point out, but I didn't succeed. That's exactly what's at stake here. You have the right. You could say, employers can pay, let's take a case outside of art. Employers can pay their staff different salaries. It's not against the provision of all men are equal. So we don't know until a court talks about it, you know? So we actually do not know. But what I do know is that I can say, if that were my room, I can say, take those works out and thank you. And if I had a contract, I might have to pay damages, but it's not penalized in the sense of, but of course, there are examples of, for example, contracts where people say, where people who marry make a contract that they will not have children. That was considered an unlawful contract based on constitutional grounds. So of course you have certain incidents where private law contracts are being nullified on constitutional grounds because they're so definitely violating central guarantees. But I look at Hans and I know it's a too complicated argument.
Thank you again.